Judge Craig Enoch, welcome to State House. Really appreciate you being on the program today. For our listeners and viewers, I want to give a little brief background. Sure. You're well-recognized person, but to some people listening that maybe have not been involved in the judicial or legislative business, they may not know your name, but you served 10 years on the Texas Supreme Court, and prior to that, another 10 to 12 years, I believe, on the District Court and also the Court of Appeals. Is that right? Did I get that correct?
That's correct. The numbers are roughly
They roughly a long time, many years of judicial service. And so we very much appreciate you being here today, particularly because of the subject we're going to talk about. So just as a little background, we did a program on the Robert Roberson case that recently popped up because the House Criminal Jurisprudence Committee held a hearing in which they intervened in the execution of a death penalty case. And people can read about Roberson, but he was convicted about 20 years ago and of murdering his young daughter. I think she was 2 years old, I believe, and got the death penalty and was set to be executed that day. And the legislative committee, the House Criminal Jurisprudence, held a hearing and had, Dr. Phil and John Grisham, and we were there. It was quite a big show. And so there's kind of two issues that really have come out about this, and this is what's so important that I wanted to have this discussion with you. One is the whole shaken baby syndrome issue, or case, cause of action or criminal action. And then there's the separation of powers issue, which is sort of over the top of that. And so there was a lot of questions. Did the House Criminal Jurisprudence Committee have the jurisdiction to actually hold a hearing and intervene? Not that they could make a decision about whether or not he was going to be executed, but he, in fact, now is got to stay because of some following things that occurred with the county and then the Supreme Court, I believe, once the separation of powers issue resolved. I believe that's correct.
Yeah. So
I'd love to get your thoughts on all of those issues. We can talk about the shaken baby, but I mean, particularly, I'm interested in how you see the state of Texas legislature intervening in a judicial matter and how that plays out. As a former Supreme Court justice.
Sure, happy to visit about it. My opinion is no better than anybody else's, but I've had a lot of years' experience, and I found, by way of background, when I was a trial judge, I kind of sort of decided, okay, what resolves this dispute in such a way that other people will kind of understand how they conduct their affairs. And I slept fine. Whatever decision I made, I slept fine because I knew there was a court of appeals. There'd be 3 judges who would review my rulings if somebody was upset and wanted to appeal. And so there was somebody checking my papers.
Okay.
And, it never bothered me that they'd go up in the Court of Appeals. I had a pretty good track record for my decisions at the Court of Appeals. But if I was wrong, I wanted to know I was wrong, because the worst thing you can have is somebody walking away and not feeling that their issues have been fully vetted. When I got to the Court of Appeals, it got more difficult to make the decision because I had 2 other judges sitting on the panel. You had 3 judges looking at it. This is generally the rule. So I had to get at least one other judge to agree with me. Well, if I had misled that judge, I still slept okay because I had the Supreme Court. If it was way off, then the Supreme Court could, with its choice, pick the case and say they're going to look at it and do whatever they want to do with it. When I got to the Supreme Court, it got infinitesimally more difficult to get a decision because I had at that court, we had 9, had to get 4 judges to agree with me.
Right.
So it's much harder to get an agreement with them. But then I started sleeping less well because there was nobody looking over our shoulder.
Yeah.
And if I somehow had gone a direction and gotten 4 to agree with me and I was wrong, there was not going to be any solution to them. That's just the way it was going to be. So by way of background, my experience had been that by the time an issue like this gets to the Texas Supreme Court, it is going to be a much more deeply thought about, much more serious resolution coming out of it, and it's not an easy case to call. One of the things I've thought about for quite some time. You see some politicization of judicial decisions where it was right. So my side was right in a political sense, and the other side, it was wrong. And so that court was wrong to join that. I mean, they see it as 2 teams out there fighting.
Right.
And
Very tribal.
Tribal, and that's the way they go. And, it's a little bit more than an umpire or a referee. But if you think the call's wrong, you're going to assess all sorts of reasons for it. But they try and use it in 30-second sound bites or 10-second sound bites. What you really have to do is read the opinion. Or as one of my colleagues, he's still serving on the Supreme Court, said many, many years ago, you measure the correctness of the opinion by the persuasiveness of the writing. So you may see an outcome, and then everybody wants to yay or nay on it because of their particular view of the political issue behind it. But there's no discussion of, well, I read the opinion, and they followed the wrong cases, or their reasoning is wrong. And this Roberson case, this issue, is one of the things where you're seeing people line up, well, it's right or wrong, or
That's right.
Roberson's a bad dude, or Roberson's a good dude, or Roberson's not well, or you see those questions. When it gets to the Supreme Court, that's really not what they're going to be answering. They're not going to be answering that kind of question. They're going to be answering the much deeper question about whether a committee can issue a subpoena, but more to the point, can it enforce its subpoena? Can the executive branch ignore the subpoena? And then does the court step in to resolve it if the 2 branches can't figure out what they're going to do? So that's where these questions come from.
It's a huge question because I've never, in 30 years of working in politics, I've never seen this kind of conflict occur. It may have occurred, but I don't think it's occurred like this. This is an interesting dilemma.
Yeah, it is, and you may get an opinion out of the Supreme Court if it goes ahead and writes an opinion in this case. You may have an opinion. The only place Roberson appears is kind of the statement of where this case came from.
Right.
But after that, it'll be more of a discussion between the branches of government.
So that's and so that's really kind of the curious thing that I found is, when we did our a recent podcast with one of the committee members, they felt like they had oversight authority over. Well, they had oversight authority. I'll say it like that. Sure. And I know their oversight authority in crim jur is over TDCJ, right. But it's not oversight over the case, the death penalty case. And so, but he was very, very sure that they needed to do something because he felt like that. I believe he explained it. We don't want to put someone to death that shouldn't be put to death. And I think maybe there was also a referral back to the 2013 statute, which is really probably more, I don't know, maybe that's a little more pointed is where they feel like they have oversight is the 2013 statute that allowed for someone who had been convicted and I don't think I think it's criminal, any criminal conviction. I don't think
right.
it's necessarily just death penalty. Could seek to a new trial through the Court of Appeals, and maybe, maybe that's the question. But in this case, it was really more about, it ended up working out as a state. Now I know eventually there's gonna be a new death warrant and all that's gonna happen, but right now everything's kind of on hold, I guess, until they figure out this issue.
And I think there are two things involved in this. One, by the way, folks may not know it, but the individual representatives are arguing among themselves in the Supreme Court. So you have some representatives saying the committee can do this, obviously the representatives on the committee, and then you have representatives not on the committee saying they can't do this.
That's right.
So it's an internal fight as well playing out, in addition to the fight between interbranches. In Texas, we call them branches rather than, they have branches of government. We call them departments. We have the judicial department. It's, I guess we want to be similar, but we want to be Texas.
Right. So we have to be different.
So we have to be different in it. So two things are going on. Yes, the legislative branch does have oversight over the operations of state to the extent that they pass the laws. They pass the laws, and to that extent, they have the right to, in my opinion, they can subpoena any they want to. And it could be somebody off of death row, or it could be somebody who's a long-term sentence or anything. If they can do this, they can subpoena them. The deeper question really is their purpose for subpoenaing them a factor to be considered? In other words, we've got arguments in this case. Well, the only reason they did that is they don't like the death penalty and they don't want him put to death, and so they did this to interfere, and the sky will fall if the court allows them to do this, because then any time a death penalty is getting close to execution, they'll just come in and get it stayed, and you'll just never have it. Well, I think that's a policy consideration about how this happens. But the issue that will be, I think, is whether the committee can in this case, can the committee enforce its subpoena? The committee can issue the subpoena. It has the power to issue the subpoena. But as the parties note, the committee members bring the action on behalf of the House, and it's the other House members are saying, well, that's not an action of the House. That's an action of the committee. So one of the questions, it may not get answered because the Supreme Court may not need to, but I see one of the answers about if the committee has the power to issue the subpoena, then would they not necessarily implicitly have the power to enforce it? If I were to look at that case, I'd say the committee has the power, but you'll see, in ordering any employee of the House, like the Sergeant of Arms or something, would not the collective body be the one necessary to do that? You see this play out very simply in other city council races.
That's interesting. I never thought of it that way. I guess I just felt like I was seeing it in terms of just the committee itself having the power to compel somebody to come and speak to the committee. But really, in order to do that, they would have to, since he's in Huntsville,
Sure.
You've got there's a lot more that goes on there. They would have to actually, transport Roberson to the State House. And when we were there, I saw these cameras set up down this hallway, and I kept thinking, because it was, it was rumored he was coming, and I think they were waiting for Dr. Phil.
Yeah.
I don't think they were waiting for Roberson. So is what I suspect. But so I don't know that I've seen, other than maybe a group of legislators saying that they don't feel like the committee had this ability to intervene in this way. I haven't seen. I know the governor definitely is and the Attorney General have said they do not have that authority, that only the governor has the power to stay, which, you know, it's an interesting thing, because I think that the way they seem to be proposing this committee hearing is not as a stay or a you know, he's innocent or guilty, but more, we just want to hear from him.
Sure.
Although obviously it raised the awareness so high that he got to stay.
You know, and it goes back to what I say. I think the court will not get involved in the question of the authority of the House to subpoena anybody they want to. So, because what some of the arguments that are being made against the subpoena is, well, there was the reasoning for the subpoena. I don't think the Supreme Court wants to get into being a decider of whether the House has a proper motive for issuing the subpoena. That's the House's business.
I guess technically they could subpoena anybody they want to.
They could subpoena anybody they want to. The question is, on that level, is the House seeking to enforce the subpoena? So I've got a committee. The House can only operate on how its committees view the legislation recommendations. And so, as the representatives argue, you know, well, some of them argue the committee can't issue the subpoena, but what happens is it's really on the enforcement side. The committee sits there, sets up the subpoena, says, we're going to subpoena them. They send out the subpoena. The witness doesn't show. Now about enforcement. The House is the body, it seems to me, as the organization, has to make the corporate decision about processing that.
So how would I you know, I've been doing this for so many years, and I still find things that I don't know about the legislative process. Okay, so the committee gets subpoenas, and then he doesn't show.
Right.
Someone decides he's not going to show.
Right.
Maybe the governor makes a call to the TDCJ and says, you're not spending the money to drive this guy down here, whatever the case may be.
Yeah.
I mean, I'm not saying that happened. I'm just saying, assume that happened. Then the next step is the enforcement, as you're talking about. So sergeant at arms, they'd send out to go and get somebody, kind of like they did when the legislature was breaking quorum and they needed to go get those legislators to come back in to make a quorum. They can send out, and that is a decision of the. I'm assuming that's a decision that comes from the Speaker of the House. I would imagine has to approve that's, as he's speaking for the House of Representatives. I think that's right.
Right.
So in this case,
well, it's because you don't have a quorum. There's a special provision that allows a majority of those in attendance at the House to order the sergeant at arms to gather them, and that can be under the authority of the Speaker.
So in this case, would they have to seek? They have to seek out the permission from the Speaker, I'm assuming.
That's part of the argument that they're making. The subpoena wasn't signed by the right person, and the authority to send the sergeant at arms to go deliver the subpoena. Those kind of issues is that organizational structure issue that, as I say, I'm not sure the court's going to reach that, but there's a lot of cases when you've got like a city council, somebody tries to do something and take some authority position and try to enforce it. If the corporate body hasn't authorized that action, it's highly unlikely the individual can move forward with any sort of enforcing what they're trying to do.
So, if the Supreme Court then just takes just the blanket issue that whether or not they have the ability to subpoena, essentially is what they would be doing, and they say, yeah, they have the right, they can subpoena, and they don't go any further than that, and then the committee comes back, and we go through the process again. What do you see as sort of the next step? Like there's going to be, it seems like if they really want to push this, there's going to be I don't want to say that, I mean, escalation, like, how do they push to the next step? Because it's sort of circular, right? If it's just about the subpoena and they say, yeah, they have the right to subpoena, and they do it again.
Right.
And then we're back to square one where we're arguing about what authority they have, or does it just go away?
I don't think it goes away. Actually, I'm half joking when I say it's not worthwhile to tell the Texas Supreme Court it doesn't have jurisdiction to decide a question, because obviously it's going to decide whether it has jurisdiction to decide the question.
Right.
And you have a concurring opinion in some, temporary restraining order that the trial judge made, where Evan Young, with two other judges joining him, Justice Hecht and Justice Huddle, Chief Justice Hecht, really is saying, this looks like a fight between the House and the legislative branch and the executive branch, and they ought to work those things out. If they don't work those things out, well, the question of whether the House can be, if the House can, through its subpoena, direct that the Department of Criminal Justice has to deliver a prisoner who's otherwise to be executed to the House for a hearing, that's a civil matter. That's not a criminal matter. Once they say it's a civil matter, then that puts it in the hands of the Texas Supreme Court to resolve it. And so I think the court, the determination, as Justice Young said, and it's a concurring opinion, so it's not the voice of the court, but sometimes you sense that they don't want to take an official position on it, but they'll let one of their colleagues write on it, and it comes out in a concurring opinion like this. I suspect this was sort of a sentiment of the court that you go figure this thing out. But if you don't, we'll be back here. And they told the trial court to help. They go back to trial court, and you kind of monitor this thing, you manage this thing, and see how it works out. And then the Department of Criminal Justice comes in, and now at the Texas Supreme Court is arguing that they're interfering with our executive function to execute Roberson. And then they raise the question, is the subpoena valid? Does the committee have the authority? Well, they issue the subpoena. To me, it's kind of the enforcement of this subpoena is the other problem that they raise. And they also say that the court doesn't have jurisdiction to decide this. It's a battle between them. And as I said, I think the concurring opinion is already decided.
Yeah.
The Supreme Court's, if they can't work it out, the Supreme Court's going to have to.
They're going to have to deal with it.
Deal with that question.
So if I could just change subjects just a little bit. So they're never really going to get, and this is kind of the question I had. They don't get to the underlying issue of how he was convicted. And I know there's a lot of there's this the other piece of it is the 2013 statute, which I don't quite understand. And that was that it'll and I think there was also an amendment to it. I mean, there might have been an amended part of that statute in 2015, maybe.
Sure.
What did that statute do, and that they're operating under? Because this is where it kind of started. Is it kind of opened the door, right, for him?
Sure. For quite some time in the criminal justice sphere, people have been very concerned about volition. Did I really intend to commit the crime? And sometimes there's a kind of the forensic science. Well, we didn't see an eyewitness identify that you did it, but we've got this science out here that when you follow the metrics of the science, it leads to the conclusion that you did it. And so there was some sense that maybe there's over time people begin to say there's real problems with the science. It doesn't account for certain variables or whatever it is. And so the statute started saying if you are convicted based on that science and it becomes challengeable later, then this is an opportunity to have your case reopened and retried. And that's where those statutes come from.
That's what the statute does. So if you were convicted based on some science that as you said is questionable
Right.
Later, then you might have an opportunity. So he does appeal, and I want to say there was probably around maybe 50 people that fell into sort of that category. That number might not be correct, but that appealed, and he was denied, and so I guess that denial came right around the time when the death warrant, I guess within that 90 days, and then he was, that day he was set to be executed. This just came right off of the press. The Texas Supreme Court ruled Friday the state legislature does not have the power to stall an execution, ending a constitutional crisis that erupted after lawmakers subpoenaed Robert Roberson III to testify before the committee 4 days after he was scheduled to be put to death. That's interesting.
Yeah.
And maybe a little unexpected. I guess depending on how the question was asked.
Sure.
Right? Would that be right?
Well, it did. As I said, I think they can subpoena anything they want to. The enforcement, can they do that? And they're going to say, I guess what they're saying is you don't have it to stall it. So,
which is what happened.
And so now they'll put it back on 90 days and they will go. So they don't, as I said, I didn't think they'd kind of reach the issue in the inner fight in the House, whether they have it. They'd be on the upper issue. Can the House enforce a subpoena against the executive branch executing its obligation to do that? Justice Young started out his concurring opinion to say the Court of Criminal Appeals decides death penalty cases.
Yeah.
The appellate has all run out. The issue has all been vetted in the proper courts coming through. The only question was left, does the House have the ability to subpoena and affect the work of the executive branch's duty to execute the law? And the Supreme Court said, and it looks like they've announced the opinion.
They're announcing no.
They're saying
I mean,
no.
we haven't read the opinion, so we don't have we'll have a chance to do that. I mean, it just came out, so but it'll be interesting to see, who was on, who was part of that decision, and if there's a dissenting opinion. As you and I know, working in the legislative and judicial bodies for the last 30 plus years, we know it's not over.
Yeah, we know it's not over.
That's one thing we can be guaranteed. It's
Sure.
not over.
Well, let me add, if the court necessarily said it had jurisdiction, because why? Because it made a pronouncement. It said the House can't stall the execution with criminal justice, by their subpoena power.
Yeah.
And to reach that question, they followed what Justice Young was saying. On that question, it is a civil question, and the Supreme Court has jurisdiction to decide the civil question. So they have jurisdiction to decide the question, and they reached the question. They said the House has no power to do that.
Very interesting. It's fascinating to me because, I love how they parsed that whole question, because it didn't have anything to do with their subpoena power. They didn't speak to that. They just said you can't intervene. It's very specific, right? You cannot intervene or stall a death penalty a death penalty case. Yeah, I'm sure there's going to be the next iteration of this will be interesting because I also think there's I don't know this to be true, but there was the last election cycle, and not this general election cycle, but the last primary cycle was pretty tough, and I know that there was some of the members that sit on that committee, or some of the members that were actually primaried in the last election cycle, and they won. I mean, they won their race, but I always wonder about this because being involved in just the politics in general, you never quite know what causes these things to erupt, and so. I wonder if that's going to continue. That'll bleed into the next, race for speaker. It's just going to be, I think these are just for things to come, right? Is what we need to be prepared for. But I guess the last kind of question I have about this whole case is, and it's just really just kind of an open question. The whole shaken baby syndrome. Criminal, what would you call it? But he was charged with shaken baby syndrome. Yeah. I mean, he was charged with as killing his daughter by shaken baby syndrome,
right?
Something like that. As I read, it's interesting how these theories come about because the American Academy of Pediatrics actually sort of developed that theory, and then some people were convicted on it, and then 6 years later, they pulled back and said, maybe it's not exactly that. It could be something else. So there's definitely, if I were, and then you have the whole issue of Roberson being, autistic, as I read that he's very severely autistic, and if you look at his interviews, he is very difficult to communicate with. Mm-hmm. So you wonder, does he really know what's happening? I mean, it's a problem. So I understand the legislature, the committee wanting to get to the bottom of that sort of issue, but that's not that's not what they do, and I think maybe that's where the Supreme Court said, you might be right. He might have had not a fair trial. Who knows right now? But right now you don't have the ability to stall what happened when he was convicted.
Maybe I guess my view. I think the Supreme Court, through Justice Young's concurring opinion, set it up that they aren't going to consider any of that. That's the Court of Criminal Appeals. That's the appellate courts. That's the United States Supreme Court, which actually looked at this, to determine the guilt or innocence. And I think some things that played out in this is the volition. I mentioned that early on. Did Roberson, as an example, intend, or did he do something that he was capable of not doing, but he chose to do it anyway? In other words, was his whatever, assuming that he shook the baby? Did he intend to shake the baby hard? Did he? I mean, those kind of questions are just nearly not answerable.
No.
And the shaken baby was really, you look at the injuries and that sort of thing, and so it's the forensics about it. Nobody saw it, but because of the way the baby presented, they say, well, this was shaken baby.
Had to be shaken baby.
Shaken baby.
Right.
And if you looked at what the arguments of the parties who were trying to stop the execution, not necessarily in the House, stop the execution, they were saying there was other evidence of ailments that the baby had and those sorts of things, really trying to, not really going to whether the baby was shaken, but whether the shaking of the baby caused the death. Well, that's the type of stuff you argue in the trial court when it's time to present that, and that's the stuff that gets evaluated on the appeals. and that's the stuff that gets presented by writ of habeas corpus. Those kind of questions aren't the kind of questions the Supreme Court was addressing.
Okay.
Because one department, one branch, the legislative branch, attempted by its effort to stop an execution. As I say, the merits. I'll be interested to see if the opinion talks about the motive for subpoenaing, or does it simply say that the timing of the subpoena, you can't be directing the department not to do its thing to stop the execution at a timing that stalls its requirement.
Its requirement, right?
And so
we'll try to put the. By the way, just for those that are listening and watching, we'll try to put the opinion in the notes of this podcast if we can make that work so that people can read it, because I think it's going to be really interesting to see that. Sort of bottom line in all this, as I read through General Paxton's his brief on it, and as I've just looked and tried to find out as much information as possible, the bottom line is it's just an absolutely sad case. It is awful what this little girl apparently had been going through for her short 2 years of life, and it's sort of like that all gets sort of missed in, all of the, is he innocent? Does he have autism, volition, all these things that start to build up around a case like this. And at the end of the day, you look and you say, this poor little baby went through some really horrible stuff because she had so many injuries already. And they say she was sickly. I don't know what that means. I've still tried to understand what that means, that she was sickly. She was sickly because she was being injured, and that's really what it looks like to me.
Sure.
By somebody. I don't know if it was him. I think it could have been his former wife or whoever had her before. I mean, I just don't know. But it's a very, very, very sad case.
It really is it's a tragic case. It's not a rare case. I'm not talking about shaken baby. It's not a rare case of children suffering harm at the hands of a relative, if not their parents, then a close relative. Again, it's just it's nearly an intractable problem. Yeah. You have. You have foster care issues. You have what do you do with the child that's in a not sustainable living condition? Yeah. But you've got no place to put them. Texas is probably the largest foster care entity in the state, with 30,000, probably 40,000 kids now who've been removed with no place to place them. You just have to remove them, and it really is. This case is really a representative of tragic. A child didn't get the opportunity to grow and thrive, and I'm not sure there's really an answer to that, except there are a lot of nonprofits, organizations, even the state, Health and Human Services, with its child protective department out there, really just working overtime, trying to keep these things from happening. Yeah. And there'll always be someone who falls through the cracks.
Yeah, that's the unfortunate thing. And I think you said it a minute ago. What is is that it's not uncommon. And that's a terrible thing that it's not uncommon that this happens, and so hopefully this next maybe this will kind of spark the legislature to take up maybe some of these issues related back to child care and I know not child care but protection of children this next legislative session, and so it doesn't get to this point, so we're not having to have this conversation. Sure. Right. But I really do appreciate it. This has been it's been fascinating, and your your thoughts on where the Supreme Court, how they do their decision making in the Court of Appeals, and how all these bodies work together has been I think, very helpful in kind of getting a better understanding of what's been going on. And we really do appreciate your time with us, and hope we can have you back again.
Sure. We'll look forward to it.
All right. Thank you, Judge.
Thank
Appreciate
you.
it.
Take care.